All right. 55th Circuit Court is now in session. The Honorable Roy G. Mink presiding.
You may be seated. In the case of People versus Vicky Louisa Johnson. You are Vicky Louisa Johnson?
Yes, sir.
All right. You're currently on probation for controlled substance possession of methamphetamine, a felony that carries a maximum penalty of 10 years in prison. The minimum is discretionary with the court. A 5-count warrant has been filed against you. Count 1 is violation of Rule 1. Count 2 is violation of Rule 4. Count 3 is violation of Rule 6. Count 4, violation of Rule 10, Condition 2.0. And Count 5 is violation of Rule 1. What the court's going to do is enter not guilty pleas on your behalf to those. We're going to appoint you, Karen Tomczyk, to represent you on these matters. And we will schedule a date and time for the next hearing that works with Clinton County. You're in Clinton County Jail, is that correct?
Yes, sir.
All right. And will you waive the right to have a hearing within 14 days so we can make those arrangements and make sure that Ms. Tomczyk gets a copy of this summons and that we get you a copy? We'll fax one down there to the jail there for you.
I mean, I'll represent myself.
What?
I'll represent myself because I don't need no further attorney fees or costs or anything.
Well, don't worry about those. If you're indigent, that's not the problem. Your real problem is your guidelines are prison guidelines. You didn't go to prison on the first sentencing because you had a deal.
I don't know. She never told me what my guidelines were when I got sentenced.
You were told at the sentencing.
I don't recall.
The court always reads them off. And the court always asks the attorneys if they're scored correctly. So, but your guidelines are pretty high. So I'm going to appoint you an attorney, okay? Now the question is, do you want a hearing within 14 days or do you want to let the court work with Clinton County and figure out a date and time that works both for Clinton County and your attorney?
The court's gonna do what they do.
No? Okay, we'll do one within 14 days then. And there's no bond since it was a summons. Are you facing new charges down there or are you serving a sentence?
I'm not serving a sentence.
So you're facing new charges? You have an attorney down there?
Yes.
What's the name of that attorney?
One moment, please. Michael Oakes.
Michael, how do you spell the last name?
Oakes.
All right. So we'll let Ms. Tomczyk know that that's the attorney so she can make a call and find out what's going on with your case so she can better represent you. All right, you're all set. We're in recess.
All right.
Represent myself.
And Mary, just to be clear, that hearing was at 11 for Parker, correct?
All right. 55th Circuit Court is now in session. The Honorable Roy G. Mink presiding.
You may be seated. In the case of Tammy Hamilton versus Bradley Martin and Bonnie Martin versus Rodney Dent, Nancy Dent, Lawrence Hovey, Diane Hovey, and the LAFCU. Council identify for the record, please.
Good morning, Your Honor. Janie Haroff, appearing on behalf of Tammy Hamilton.
Good morning, I'm JJ Klaus, appearing on behalf of Brad and Bonnie Martin.
Morning, Your Honor. I'm Robert Backus. I'm here on behalf of Mr. and Mrs. Hovey.
Honor, Danica Powell on behalf of LAFCU.
Morning, Your Honor. Scott Kramer on behalf of Big Rapids Realty and Kelly Rietzel.
And previously, the court heard a motion to bifurcate the trials in this matter into two issues. Court is going to grant that motion, feels that would be the convenience for the court. I know that some of the objections were that the testimony would have to be doubled, but you really don't. The court's going to hear the first trial or whatever those witnesses say. Court's already going to have heard that. And if counsel wishes, they can either during their opening or at some point during the trial, they can do a summation of what those facts were that brought out in that testimony or in that closing. So I think the two issues are pretty separate. And I think it'd be more convenient for the court to do it in the bifurcation trial. So the court will sign an order upon presentation. Anything else anybody wants to discuss today?
Your Honor, this is Scott Kramer. I represent the defendants in kind of what I would perceive as the second component of this case, which was bifurcated. I guess I just would be curious if we could maybe have some instruction from the court on entertaining the possibility of a stay of the second of the misrepresentation claim. I think even discovery in that action is going to be dependent on the outcome of the first. And so my strong preference would be to kind of put the misrepresentation claim on ice while the boundary dispute is resolved.
Anybody else?
Your Honor, I would only indicate, this is Bob Backus. I'm on both sides of the case here, and I do have discovery pending. I represent Mr. and Mrs. Hovey. There is discovery pending. I think the responses are due shortly. I don't have any particular objection, I don't suppose, to a stay. Despite where we sit, trying to find an efficient way to get through this case and don't seem to be having much success doing it. So, but I'm certainly not looking to drive up the costs before the same might be necessary. So in regard to Mr. Kramer's request, I guess I just leave that to the court.
All right. Anybody else have any comments? All right, the court's not going to issue a stay at this point. Feel free to do what you wish on that discovery, delay it if you wish. There is a motion for summary disposition stated scheduled for the end of June. I guess the parties will know more at that point. And the court will probably, if it has the two trials, we'll probably schedule 60 days between the trials anyways, just so that you have some extra time on those other issues. Okay?
Thank you, Your Honor.
All right, we're in recess.
Yeah.
All right.
The Honorable Roy G. Mead presiding.
Good morning.
Morning, Your Honor.
Morning, Your Honor.
In the case of People versus James Scott Parker II, counsel identified for the record.
Thank you, Your Honor. Todd Diedrich appearing on behalf of Mr. James Parker II.
Agent McConnell on behalf of the probation department, Your Honor.
And you are James Scott Parker II?
Yes, I am, Your Honor.
All right. You're currently on probation for controlled substance possession of methamphetamine. A felony carries a maximum penalty of 10 years in prison, minimum discretionary for the court. The 2-count violation was filed in this matter. And how do you wish to proceed, Mr. Diedrich?
Your Honor, I believe that Mr. Parker would plead guilty to count 1 and 2. There was a recommendation in the file, but it's my understanding that he has now paid off his costs and fines in full. So you're,
Yes.
and he actually just did that through my office. There was a balance, I believe, of $409.60, and my staff helped him make a credit card payment over the phone to pay that off.
All right. How old are you, Mr. Parker?
30 years old, sir.
You raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Charged with count 1, violation of condition 2.8, and count 2, violation of condition 9.7. One of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. Do you understand the one of 3 possible pleas you may make?
Yes, Your Honor.
Answering the count 1, violation of condition 2.8, how do you plead?
Guilty, Your Honor.
Answering the count 2, violation of condition of 9.70, how do you plead?
Guilty, Your Honor.
You understand that if your pleas are accepted, you will not have a hearing of any kind and therefore give up the following rights. The right to have a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford one. The court would appoint one for you. You do have Mr. Diedrich representing you on this matter. That the maximum possible penalty could be 10 years in prison. The minimum is discretionary with the court. That you give up the right to appear at a hearing, cross-examine witnesses, and present evidence. You give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. You give up the right to remain silent and not have that silence used against you during the hearing. And you give up the right to testify at the hearing if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights.
I do, Your Honor.
Is there any plea agreement, Mr. Diedrich, at all, or no?
No, Your Honor.
All right. Has anyone promised you anything to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Your Honor.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
Yes, it is, Your Honor.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes, I have, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
And part of your probation was to complete outpatient or residential substance abuse treatment when you were referred by the field agent, is that correct?
Yes, Your Honor.
And the field agent referred you to go to get into substance abuse treatment, is that correct?
Yes, Your Honor.
And you were going to 10/16, but on or about February 8th, you were unsuccessfully discharged from that treatment, is that correct?
Yes, Your Honor.
And you were to set up a installment payment agreement and make payments regarding the fines and costs, is that correct?
Yes, Your Honor.
And that, as of March 3rd of 2021, you failed to comply with that agreement, is that, or that, condition, is that correct?
Yes, Your Honor.
All right, but you now have paid those off, is that correct?
Yes, Your Honor. Paid in full.
All right. Court finds a factual basis for the plea. Has the court complied with court rules?
Yes, Your Honor.
Court, to satisfy the plea is understandably, voluntarily, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Is there any recommendation as to sentence from the department?
Well, Your Honor, the recommendation that I had states 15 days in jail, 7411 status revoked, regular probation for 1 year, must complete outpatient substance abuse therapy, and must set up and file a payment agreement until all money is paid off. Then it says additional fines and costs to be determined, mostly the court-appointed attorney fee, I believe. And so I was hoping to just do some allocution in the court's willing to allow.
Do you wish to go to sentencing today, or do you wish to have an updated case report done?
It might be beneficial to have an updated report done. It's up to the, I don't have an objection either way, quite honestly, Your Honor. You know, he's paid off his costs and fines. He's agreeable to going to the outpatient treatment. I'm hopeful that the court wouldn't revoke his 7411. He's been employed for about 2.5 years with Leather Trust.
Why don't we have an updated case report done and go that route? And we'll set sentencing for June 28th at 9:40 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
That'll give Mr. Parker some additional time to comply with all the rules, all right?
Thank you. Mr. McConnell, does he have to contact you?
Just his normal report date. Mr. Parker, just ensure that you report to me on your normal report date. I believe it's June 3rd.
Okay, thank you.
Thank you, Mr. Dietrich. Thank you, Your Honor.
We're in recess. Thank you.